the EIP folder for it, it says one thing. So I've seen.
Good morning and welcome to the April 30th, 2026 meeting of the Texas Commission on Environmental Quality. For the record, I'm Chairwoman Brooke Popp, and joining me today are Commissioners Katarina Gonzalez and Tanya Miller, our General Counsel, Mary Smith, and our Interim Public Interest Counsel, David Timberger. For each item that argument or discussion is allowed, we'll inform the parties and the public of time limits for their discussion. Registration closed at 9:30, but if you'd like to address the commission on a particular item, please visit our registration table or email us online at agenda.tceq.texas.gov with your name, affiliation, and the agenda item you'd like to comment on, and we'll do our absolute best to accommodate your request. For those making presentations, please wait to begin your presentation until I or Mary have asked you to begin the presentations, and please check to make sure your line is unmuted before proceeding. With that, Mary, first item, please.
Item number 1 is the consideration of the ALJ's proposal for decision and proposed order concerning the enforcement action against Carbon Sequestration Incorporated. Oral argument will begin with the ED, followed by the respondent, and then OPIC. The ED may reserve time for rebuttal as the ED bears the burden of proof in this matter, and each party will have 5 minutes of oral argument time in accordance with the Commission's standard practice. With that, we begin with the ED.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, my name is Taylor Pearson with the Litigation Division. Tiffany Chu with the Enforcement Division and Charles Collins with the Beaumont Regional Office, the assigned enforcement coordinator and investigator, are available by phone if you have questions for them. This enforcement action has 2 violations: failure to notify the ED of any changes concerning waste management methods in connection with a recycling notification of intent, and causing, suffering, or allowing or permitting the unauthorized disposal of over 4,000 tons of wood waste. On May 21st, 2024, TCEQ staff conducted an investigation of respondents' property for which a composting and biochar recycling notification of intent had been issued. The investigation found that no composting or production of biochar was taking place at the facility, and instead respondent had buried over 4,000 tons of wood waste and intended the waste to remain buried there for at least 100 years. Respondent failed to notify the ED that it was not composting or producing biochar, as is required to do under TCEQ rules. Further, because the wood waste at the facility was not being composted or converted into biochar, it was not covered by the NOI that was issued and therefore not exempted from regulation as a waste. The buried wood therefore constituted municipal solid waste disposal for which a permit was required. Respondent did not and does not have an MSW permit for the facility and therefore caused the unauthorized disposal of waste in violation of TCEQ rules and state law. Respondent contends it recycles waste wood into carbon removal credits immediately upon burial. At the evidentiary hearing, respondent's expert witness on carbon removal credits stated, without qualification, the waste wood used in the alleged manufacture of carbon credits at respondent's facility was not substituting any raw or virgin material that could otherwise be used to create a carbon credit, which is a requirement for the waste wood to be considered a recyclable material under the Texas Health and Safety Code and TCEQ rules. Because the wood waste buried at respondent's facility is not recyclable material under the rules, the administrative law judge appropriately found respondent's activities are not recycling and therefore not covered by the recycling notification of intent it was issued. Respondent stipulated to the penalty calculation at the evidentiary hearing, and the record reflects the corrective actions as recommended by the ED are appropriate. The unauthorized disposal of at least 4,682 tons of waste wood at respondent's facility is ongoing, and removal of the waste wood is necessary to prevent said unauthorized disposal and its negative environmental impacts, both documented and potential. For the reasons provided in the ED's filings, we respectfully request you approve the administrative law judge's proposed order with the ED's exception. We also respectfully request you deny respondents' proposed exceptions, and we are here to answer any questions that you may have, and we reserve the remainder of our time for rebuttal.
Thank you very much. Respondent?
I believe that's Mr. Chris Knopp.
Online at all? Mr. Knopp or Clayton Sanders? All right, with that, we'll go to OPIC.
Good morning, present commissioners.
Oh, howdy. Yes, is this Mr. Knopp?
It is.
Good morning.
Good morning. I'll be speaking on behalf of carbon sequestration. Can you see me?
We cannot see you, but we can hear you.
Thank you. May I begin, or do we have any preliminary matters we would like to address?
No, you can begin.
Thank you, commissioners, for your time this morning. The ruling against carbon sequestration stems from one fact only, and that is finding of fact 18. Finding of fact 18 is that wood waste used in connection with the sale of corks does not substitute any raw or virgin material. Otherwise, our process would be considered recycling. Let's start with the actual language of the statute. Texas Health and Safety Code, section 361.42111, defines virgin material as, quote, a raw material used in manufacturing that has not yet become a product. In our case, purpose-grown timber or bamboo, grown specifically to be harvested and buried, is clearly virgin material under that definition. It has not yet become a product. When an investment bank buys a carbon dioxide removal credit made from waste wood, they are choosing not to buy a carbon dioxide removal credit made from virgin purpose-grown material or virgin forests. That is exactly the substitution the recycling statute requires, and we meet that definition. This is no different than recycled aluminum displacing the need to mine virgin bauxite. The fact that we start with waste wood does not disqualify us. It proves we are doing precisely what the law intends. The admitted TSB methodology proves that corks can be produced using virgin biomass. The Puro Earth TSB methodology, which carbon sequestration works under, edition 2023 version 1, was admitted both as ED Exhibit 15 and CSI Exhibit G without objection. That expressly allows cork production from virgin biomass in the following ways. 1, through managed forests. 2, natural forests. 3, purpose-grown materials on non-forest land. And 4, land clearing in construction. Each of these is a raw material that has not yet become a product, virgin material under section 361.42111. The ED did not refute or challenge these provisions at hearing or in briefing. CSI's, Carbon Sequestration Incorporated, waste wood substitutes for those virgin sources. Because corks can be produced using virgin biomass, when CSI produces a cork using waste wood instead, the waste wood substitutes for the virgin biomass that could have otherwise been used, satisfying 361.4215 requirement that recyclable material be, quote, used in the manufacture of products which may otherwise be produced using raw or virgin materials. The statute says may otherwise produced, not is otherwise produced. The question is capability, not practice. The admitted methodology proves capability. Finally, Dr. Gooding's testimony does not foreclose this argument. Dr. Gooding answered no when asked whether waste wood at CSI's facility substitutes any raw or virgin material. As his affidavit clarifies, he understood the question narrowly, whether CSI
Mr. Knopf,
specific...
I'd like to remind you that your remarks need to be limited to evidence that's in the administrative record from the hearing. Thanks.
Okay, that's the affidavit is basically at the hearing. Dr. Gooding was talking about the current operations, not what may have been substituted. And so his no was about the actual material that we were using, not what we were potentially substituting. The admitted methodology proves that we can substitute for virgin materials. Commissioners, this has been going on for over a year now. In the beginning, TCEQ said that this was not a product. It relented on that, had no evidence otherwise. It said that there was evidence of environmental. There's no evidence.
Your time is up, but I'll give you 1 minute to wrap it up.
Thank you, Commissioner. And so this is a product. It's new. It's untested. It hasn't been around long, but for that reason, we ask that you reverse finding of fact 18 and conclusion of law 13, because this is legally recycling. There's no environmental harm, and CSI Hardin's waste is recyclable material because it displaces virgin material, as I've shown from evidence that's already in the record. And thank you. If you have any questions, I'm open for those.
Thank you very much. Any questions for Mr. Knopf? Nope. OPIC, Jessica, you have 1 extra minute if you need it.
Thank you. Good morning, Chairwoman, Commissioners, Executive Directors, attorneys, and staff. For the record, I'm Jessica Anderson with the Office of Public Interest Counsel. We participated in the hearing and evaluated the evidence and arguments presented. In agreement with the ALJ's proposal for decision, OPIC recommends that the Commission, 1, find that respondent carbon sequestration committed the alleged violations and that the proposed penalty is just and in accordance with applicable law and the Commission's penalty policy. And 2, order carbon sequestration to pay the proposed administrative penalty of $5,625 and implement the Executive Director's proposed corrective actions. These corrective actions include the immediate cessation of municipal solid waste disposal at the facility, removal of all municipal solid waste from the facility within 30 days, disposal of said waste at an authorized facility, and submission of a notice to cancel authorization to the Commission, and submission of written certification within 45 days with supporting documentation to demonstrate compliance with the aforementioned corrective actions. The Commission alleged that carbon sequestration committed the following 2 violations. 1, carbon sequestration caused, suffered, allowed, or permitted the unauthorized disposal of municipal solid waste in violation of 30 Texas Administrative Code, sections 330.15A and C. And 2, carbon sequestration failed to provide written notice to the Executive Director of any changes concerning waste management methods by conducting activities not authorized under its notice of intent in violation of 30 Texas Administrative Code, section 330.11B. It is uncontested that carbon sequestration does not have a municipal solid waste permit. Rather, respondent is authorized only to operate a recycling facility and is not authorized to dispose of municipal solid waste at the facility. Further, it is uncontested that carbon sequestration buried a large quantity of wood waste in subterranean vaults at the site. While carbon sequestration has operated this facility under the presumption that the burial of wood waste and the subsequent creation of carbon dioxide removal credits satisfies the recycling guidelines of their notice of intent, neither OPIC nor the ALJ were persuaded that the creation of these credits satisfies the definition of recycling found in Texas Health and Safety Code section 361.421. While OPIC appreciates that carbon sequestration has long-term plans to produce biochar from the waste received at the site, the time limits on recycling imposed by 30 Texas Administrative Code section 328.4 indicate that respondent is not compliant with the terms of the notice of intent. Testimony at the hearing on the merits described recycling as a constant churn that moves material onto and away from the premises, and no such process occurs at this facility. By burying wood waste at this site and failing to recycle said waste, carbon sequestration disposed of municipal solid waste in violation of a permit of the Commission. Further, carbon sequestration did not obtain written authorization from the Commission to dispose of wood waste in this manner. Additionally, carbon sequestration was required to notify the executive director in writing of changes to its waste management methods in accordance with 30 Texas Administrative Code section 330.11b. It is uncontested that no such notification was provided. As discussed, by burying wood waste at the facility, carbon sequestration disposed of municipal solid waste. Carbon sequestration is not authorized to conduct this activity. Rather, the Commission authorized carbon sequestration to produce biochar through composting and/or mulching clean wood materials. No evidence was observed or provided that composting or mulching activities occurred at the facility. The notice of intent stated that carbon sequestration would comply with the timelines mandated by 30 Texas Administrative Code section 328.4. Here, carbon sequestration intended to keep the wood waste buried for over 100 years, which far exceeds the time limits provided in the notice of intent and required by rule. Further, the waste has now been buried on site past the 270-day outside limit for recycling materials. Carbon sequestration was bound by the constraints of the recycling notice of intent and failed to notify the executive director in violation of 30 Texas Administrative Code section 330.11b. Additionally, the ALJ found that the proposed administrative penalty and corrective actions were appropriate given the proven violations, and OPIC is in agreement. For the foregoing reasons, OPIC supports adoption of the ALJ's proposal for decision. Thank you, and we are available for any questions.
Thank you, Jessica. Edie, you have 2 minutes and 45 seconds, including that 1 extra minute for rebuttal.
Thank you, Chairwoman. Respondent failed to make any argument concerning the wood waste and whether it was a raw or virgin material at the evidentiary hearing and in either of its legal closing or its reply to the ED's legal closing. Timeliness aside, respondent's arguments have no merit. At best, they imply that it's conceivable that the corks that are sold by respondent could be produced by a raw or virgin material, but for the reasons argued in the ED's reply to respondent's exceptions, fail to establish that by a preponderance of evidence. No terms in the document referenced by respondent are defined, and respondent's interpretation of those documents flatly contradicts the unambiguous testimony of its own expert witness on corks. Moreover, quote-unquote, producing the corks respondent sells with raw or virgin material would negate the premise upon which they allegedly reduce carbon emissions. Cutting down and burying virgin timber without putting it to any other beneficial use generates carbon emissions for no purpose other than to potentially facilitate the sale of a digital asset. The rationale behind the carbon offset of respondents' corks requires the input waste wood to be diverted from a waste stream that releases more CO2 than disposal through burial. There is no alternative. Thank you.
Thank you very much. I would find that the record supports the ALJ's determinations. I agree with the ED's testimony and evidence established the 2 violations and the need for the recommended corrective actions by a preponderance of the evidence. I'd also find that the ALJ correctly applied the relevant law in her proposed order. I'm ready to adopt the ALJ's order as modified by the ED's exception with 2 additional modifications. I would correct the rule citation in conclusions of law 6 and 15 so that the subsection number is 91 instead of 90. I would also add a paragraph to the ordering provisions stating that the noncompliance with a commission order may lead to a referral of the case to the OAG, which is a customary paragraph included in commission enforcement orders. I'll stop there and see what my fellow commissioners think.
I'm in agreement.
I'll make the motion then. I move that we adopt the administrative law judge's proposed order as modified by the ED's exception and recommended by the administrative law judge in her reply letter dated March 12th, 2026, with the following additional modifications. A, to correct a rule subsection citation, replace 90 with 91 in conclusions of law 6 and 15, and B, to clarify that noncompliance with the commission enforcement order may result in the executive director referring the matter to the Texas Office of the Attorney General. Add ordering provisions 4A to state the executive director may refer this matter to the Office of Attorney General of the State of Texas for further enforcement proceedings without notice to the respondent if the executive director determines that the respondent has not complied with one or more terms or conditions in this order.
Second.
All those in favor say aye.
Aye.
Motion passes. Thank you. Thank you, Taylor. We're on to item 2.
Okay. Item number 2 is the consideration of the motion to overturn the executive director's order designating the city of Old River Winfrey as an authorized agent to regulate the use of on-site sewage disposal systems within its jurisdiction. Presentations will begin with the ED, followed by the city. Currently, we don't have a representative from the city signed in, but and then we'll go to OPIC, but the ED may reserve time for rebuttal as the ED bears the burden of proof. Each party will have 5 minutes of oral argument time in accordance with the commission's standard practice.
Good morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. For the record, I am Ryan Rackwitz of the Environmental Law Division, representing the Executive Director. With me today is Melissa Keller, Deputy Director of the OCE's Program Support and Environmental Assistance Division. Under 30 Texas Administrative Code, Chapter 50.139, an MTO must be filed no later than 23 days after the Chief Clerk mails notice to the Executive Director's decision. Additionally, an MTO must identify with particularity the subject of the complaint, the erroneous decision, any erroneous evidentiary or legal rulings, and the legal factual basis for the claimed error. Lastly, TCEQ's rules in 30 Texas Administrative Code Chapter 50 state the Commission may amend or modify a permit or take any other appropriate action, including the consideration of an MTO filed by the Executive Director, and remand an application for further action by the Executive Director under 30 TAC Chapter 50.137. When the Commission holds jurisdiction over the application, the City of Old River Winfrey's new ordinance, which complies with the Commission's standards regarding OSSF sewage facilities under 30 TAC, Chapter 285, also seeks to adopt more stringent requirements. The City then submitted an application to the TCEQ for review and approval of the City's ordinance so that the City may proceed with implementation of its proposed OSSF regulations. Upon receipt, the Executive Director's staff reviewed the City's application and new ordinance, which was determined to be in compliance with the applicable laws and requirements, including the rules in 30 TAC Chapter 285 relating to the OSSF requirements. Upon her staff's transmittal of documents and draft order relating to the OSSF, the Executive Director, for her consideration and signature, a page from the certified copy of the city's ordinance was inadvertently omitted. That omitted page reflects the City's intent to adopt the more stringent requirements which are allowed under Chapter 285.10B 4 through 5. Subsequently, the Executive Director's review of the City's application and the order she signed on February 18, 2026, do not reflect the City's proposal to adopt these more stringent standards. Upon the Executive Director's staff review to the notice to proceed, which was issued by the Office of the Chief Clerk on February 26, 2026, her staff discovered the inadvertent omission and promptly informed the Executive Director of the necessity to file this MTO, requesting a remand to the ED so she may sign an amended order to supersede the order she had signed on February 18, 2026, that would then be consistent with the City's intent to adopt the more stringent OSSF standards as reflected in the new ordinance. For these reasons, the Executive Director recommends that the Commission grant her MTO and remand the city's application for further action by the Executive Director. Thank you, and we're available for any questions.
Thank you, Ryan. Is there a representative for the applicant here or online? Well, with that, we'll move on to OPIC.
Good morning, Chairwoman, Commissioners, General Counsel, and the Executive Directors, attorneys, and staff. I am Michael Rakowskis for the Office of the Public Interest Counsel. OPEC supports granting the motion to overturn filed by the Executive Director's Office. OPEC maintains the position taken in our brief that the motion should be granted because the current signed order does not reflect the intention of the applicant in submitting the application or in the Executive Director's signing and approval of the application. Furthermore, the absent section of the application reflects the city's intention to adopt more strict standards pursuant to Chapter 285 of the Texas Administrative Code. As this motion to overturn was filed with the intent to fix this omission, OPEC would be in favor of the Commission granting the motion. Thank you, and I'm happy to answer all questions.
Thank you, Ryan. Michael, Ryan, you have 2 minutes and 1 second left for rebuttal, should you decide to use it.
No further rebuttal. Thank you.
Right. Thank you, Ryan. All right, I agree that since the ED's order did not attach and incorporate the full city ordinance, the order should be overturned and remanded to the ED so that she may issue a new order with all the necessary pages attached. Colleagues, you have additional thoughts?
No, I agree.
I'm in agreement as well.
Wonderful. Do I have a motion?
I move that we overturn the Executive Director's February 18, 2026 order designating the city of Old River Winfrey as an authorized agent to regulate the use of on-site sewage disposal systems within its jurisdiction, and that we remand the application to the Executive Director for further processing.
Do I have a second?
I second.
All those in favor say aye.
Aye.
The motion passes. Moving on to item 3.
Item 3 is the consideration of the application by the LCRA for a major amendment with renewal of TIPD's permit number WQ000210500. The parties have been notified that the commissioners will not take oral argument but may ask questions. Those who have signed in will be noted for the record. As a courtesy to the legislature, however, the commission allows members, staff to read letters to the commission on items. The commission's consideration of this item must be limited to the parties' filings and briefings pursuant to the Texas Government Code. I understand that we have Senator Colkhurst's General Counsel and Legislative Director here to deliver some remarks on her behalf.
Good morning, Chairwoman, Commissioners, and General Counsel. My name is Jacob DeSelms, and I'm here on behalf of Senator Lois Colkhurst to read a letter she prepared for this hearing. Dear Chairwoman Pop and Commissioners Gonzalez and Miller, as a longtime supporter of thermal generation, I'm grateful for this opportunity to address you all today as you consider the permit amendment application for the Fayette Power Project. I write to you to voice concerns my constituents have brought to my attention regarding this application. Specifically, I have heard repeatedly of their concerns over the plant's attempts today to remove selenium limits from several of the plant's outfalls, limits that are currently in place and have been in place for years. The people of Fayette County are concerned about the pending permit amendment that would allow these selenium limits to be removed from their outfalls. A lot of information has been circulating around the community about what this would mean for nearby residents, groundwater, and surface water downstream. To that end, and in the interest of full transparency in this process, I am requesting that the Commissioners and TCEQ make clear that if the amendment is issued, the permit will continue to protect water quality and not degrade the environment in the area. My constituents have legitimate concerns that these amendments could have negative impacts on their health and the health of their community. And while I am assured that these same constituents fully support the continued operation of the power plant, they are right to demand answers on whether their health will be negatively impacted by these changes. Further, I understand that once a permit is issued, the TCEQ ensures that the permit holders comply with the permit to ensure the protection of the community and the water. My office will work with the TCEQ to ensure that this permit, if issued, is upheld to the environmental standards put in place by the Commission. Thank you again for allowing me to have this letter read into the record today. I'm grateful for the opportunity, and I appreciate your hard work. Thermal generation is essential to the strength and security of our grid, but we must also ensure that the people of Fayette County are able to continue to enjoy the use of their property and water as they do today. Sincerely, Lois W. Colkhorst.
Thank you. Appreciate you being here.
Thank you.
Item 3, before us we have an application by LCRA to renew and amend its TIPD's permit. The Commission received hearing requests from 11 individuals on this matter. When considering hearing requests for this type of application, the Commission considers a two-step analysis. First, we must determine whether a hearing requestor is an affected person, and second, if the Commission finds that a requestor is an affected person, we determine whether that person raised issues in their hearing request that are referable to SOA. To be considered an affected person, a requester must explain how they will be affected by the application in a way that is not common to members of the public. The hearing requester must also file both timely comments and a hearing request that identifies their personal justiciable interests. Finally, the identified concerns must be within the Commission's jurisdiction to address in its authorization. I agree with the OPIC and the ED that none of the requesters in this matter qualifies as an affected person. The requesters either failed to file timely comments during the comment period, did not identify a personal justiciable interest, or do not live in close proximity to the facility or discharge route such that they have established a personal justiciable interest distinguishable from the general public. So I deny all hearing requests in this matter. I'll stop there and see what my fellow commissioners think.
I agree. I also just want to note that I think the record establishes that the executive director conducted a thorough review of the application and found that the draft permit was protective of human health, existing surface and groundwater quality, the environment, the health of aquatic and animal life, and existing designated water quality related uses. So I think the draft permit complies with all applicable statutory and regulatory requirements.
Thank you, Commissioner Gonzalez. Commissioner Miller.
I also agree with your determination on affected person status, and I also wanted to note that the effluent limit that the amendment is requesting would remove a constituent that the applicant has demonstrated is not being discharged in a treatable concentration and would not be harmful to human health. In addition, the longer duration rainfall event change is supported by EPA regulations. Therefore, I would support moving this forward.
Thank you, Commissioner Miller. Let's go to the request for reconsideration. A couple of the hearing requesters also requested that the Commission reconsider the issuance of the draft permit. Those RFRs expressed general concerns regarding holding a public meeting and changes to the selenium effluent limits. I don't believe that the RFRs provided any additional information for the Commission to consider that was not already sufficiently reviewed and considered by the ED. And I believe that the ED's RTC adequately addresses the concerns raised in the RFRs. So I would deny the RFR. Regarding the permit amendment, the application and the ED's technical review demonstrate that the permit will be protective of human health and the environment. The ED's response to comments also sufficiently responds to the timely comments that were received. So I'm prepared to move forward with issuing comments. Colleagues?
I'm in agreement.
In agreement.
Do I have a motion?
I move that we deny all hearing requests and requests for reconsideration, issue the major amendment with renewal of TPDES permit number WQ 0002105000 to Lower Colorado River Authority as recommended by the Executive Director, and adopt the Executive Director's response to comments.
Is there a second?
Second.
All those in favor say aye.
Aye.
Thank you very much. The motion passes. We will move on to item 4. I'm going to let everyone have time to shuffle.
Item number 4 is the consideration of the petition by Century Property Acquisitions, LLC, for the creation of Rocket Ranch Municipal Utility District of Ellis County. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
All right, item 4 is a petition to create a municipal utility district with road powers located entirely within Ellis County. We have 2 hearing requesters in this matter from Ellis County and Senator Bob Hall. When considering hearing requests for district creation petitions, we must determine whether a hearing requester is an affected person who is entitled to a hearing. When considering whether a governmental entity is an affected person, the Commission must consider the governmental interests that the entity explains will be affected by the petition. We also consider the government's statutory authority over the government's interest in the issues relevant to the petition. For individual hearing requests, the Commission must consider whether the individual has identified a personal justiciable interest not common to members of the general public. Ellis County cites its statutory authority over functions relevant to our consideration in creating this district, including transportation, drainage, and water quality. The county explains how these relevant concerns impact its ability to ensure the health and safety of its residents, as well as its impact to its services and functions. Ellis County establishes a clear connection between its statutory authority and its relevant interest that entitles it to a hearing. The county's filing of the hearing request and the other district creations within its boundaries do not prevent it from obtaining party status in its district creation. The county has an important role in protecting its citizens, and it's explained how that role will be impacted by the creation of this district. Therefore, I believe its hearing request should be granted. The county points out the catch-22 in the petitioner's argument, that our rules state that the Commission must consider the county's statutory authority over interests relevant to the petition. However, in the petitioner's view, that same interest disqualifies the county from receiving a contested case hearing. I found that the county's argument was very compelling. While it's true that Ellis County has authority over the approval of roads and drainage facilities within the district, that cannot prevent the county from seeking affected person status from the Commission. No law requires the county to select a single remedy, and our governing statutes do not allow the Commission to deny a request for a contested case hearing simply because the affected party has other avenues of redress. The mere fact that the other potential remedies may exist doesn't preclude the county from availing itself of our process. And as I've said previously, the legislature's grant of authority to the Commission to create taxing entities is something I take very seriously. Leadership has made tax relief for its citizens a top priority. MUDs create long-term tax obligations for its residents, and I feel that we should not add financial burdens without absolute and careful scrutiny. I believe the law is clear that Ellis County is an affected person, and its hearing request should be granted. I've also reviewed Senator Hall's hearing request, and he has failed to show how he will be affected by the creation of the district in a manner not common to members of the general public, and I would therefore deny his hearing request. I recognize that this hearing request matter is similar to recent MUD creations that I've heard at my last few agendas, so I will ask my fellow commissioners if they have thoughts. Commissioner Gonzalez.
I do have thoughts.
Go for it.
I found this one request to be a little more robust, but although the county identifies its authority over public safety, drainage, and transportation, I did not find that it meaningfully articulated how the district creation will affect those interests, and I do not believe the county's hearing request sufficiently explains how the county will be impacted by the specific developments contemplated by the petition, especially given that they have authority over roads and drainage that they have to have approvals on separately. Given the general concerns, lack of specificity, the county did not sufficiently identify a personal justiciable interest in my view. The executive director reviewed and considered the comments raised during the application review process, and I believe the county had an adequate opportunity to provide its opinions on the petition as is done here. In addition, I think that If the legislature had intended for Texas Water Code 54.0161B2 to require contested case hearings, they would have expressly stated that as such. Instead, they have this process where the county is able to meaningfully, I think, meet the requirements of that section by their opportunity to comment and express their opinion there. Thus, I do not believe that the county sufficiently identified a personal justiciable interest affected by the application as required by 30 Texas Administrative Code, Section 55.251C2, and would deny the county's request. In addition, I agree with the ED and OPEC that Senator Hall does not qualify as an affected person, and I would deny his hearing request. Senator Hall did not include any information relating to his location, distance to the district, or how or why he would be individually affected by the proposed district, and as such failed to identify a personal justiciable interest related to the petitions. Thus, I would deny all hearing requests. I have reviewed the ED's technical memo and other documents supporting the petition, and I believe that the information shows that the proposed district is feasible, practicable, and necessary, and would be a benefit to the land to be included in the district. I would also approve the district's request for road powers and appoint the temporary directors listed in the ED's technical memorandum. I will note that it is our duty to ensure that districts with taxing authority are developed responsibly, and our district creation process, I believe, is robust and thorough to ensure that that happens. Our process requires petitioners to submit extensive information, and our staff carefully scrutinizes this information during its administrative and technical evaluation before determining whether a petition complies with statutory and regulatory requirements. Districts are a cornerstone of how Texas can accommodate the rapid population growth as they provide essential infrastructure in areas where cities are not providing services. I do not take the ability to create taxing entities lightly, and I think our rules and processes have the appropriate measures in place.
Thank you, Commissioner Gonzalez. Commissioner Miller.
I agree with both of you on Senator Hall that he did not show a personal justiciable interest. I also believe that this is a little bit different than my previous comments about from this dais. In this instance, I believe Ellis County has shown that they qualify as an affected person. Based on Ellis County's identified statutory authority over an interest in these issues, the county's explanation of that relationship between its stated interests and the Commission's jurisdiction over districts and the proposed district's location entirely within the county's boundaries, I believe Ellis County has demonstrated that it qualifies as an affected person in this manner. The county is required to articulate a specific concern tied to the application that goes beyond merely listing its statutory jurisdiction. It must explain how the regulated activity poses a plausible and discernible impact on its legally protected interests. Without such a showing, a county's generalized interest is insufficient to establish affected person status. Although the county's statutory authority is relevant, it must be coupled with a substantiated concern demonstrated how the proposed district will interfere or otherwise impact the authority in a concrete way. In this instance, I want to make clear, I believe these are things that we have to look at case by case. And so in this instance, the county has clearly and specifically shown how their statutory authority will be impacted by the creation of this district, and I would grant them affected person status.
Thank you, Commissioner Miller. I move that we grant
Another thought on that.
Oh, I'm sorry.
That's okay.
Go for it. Okay.
Given that both commissioners are wanting to grant that status, I would suggest that we include a maximum duration of this hearing of 180 days from the preliminary hearing to issuance of the proposal for decision.
I would second that.
Yep, I'm fine with that.
Do you want me to make the motion? Well,
Yeah.
but you go ahead with the,
With adding that in.
yes, with adding that in.
Well, let me add it in so I don't mess it up. Hold 1 second.
I'll go ahead and make the motion. I move that we grant the hearing request of Ellis County, deny the hearing request of Senator Bob Hall, refer the matter to SOA for a contested case hearing on the petition, and refer the matter to the Commission's Alternative Dispute Resolution Program to run concurrently with SOA's scheduling process, and that we specify that the maximum duration of the hearing is 180 days from the preliminary hearing to issuance of the proposal for decision.
Thank you. Do I have a second?
I second.
All those in favor say aye.
Aye.
Aye. Thank you. All right, moving on to item 5.
Item number 5 is the consideration of the petition by Hoodoo Land Holdings LLC for creation of Northfield's Municipal Utility District Number 1. The parties have been notified that the commissioners will not take oral argument but may ask questions.
All right, item 5 is a matter that involves a petition filed by Hoodoo Land Holdings LLC for the creation of Northfield's Municipal Utility District Number 1 in Kaufman County. The TCEQ received hearing requests from Senator Bob Hall and Representative Keith Bell. After reviewing their hearing request, I agree with the ED and OPIC that neither requester identified a personal justiciable interest and therefore does not meet the statutory requirements for a contested case hearing. Therefore, I believe that we are compelled to deny the hearing requests. I would also grant the petition for creation, finding that the petition satisfies all applicable statutory and regulatory requirements, grant the request for road powers, and appoint temporary directors as recommended by the ED. Colleagues?
I agree.
I agree.
Thank you. Do I have a motion?
I move that we deny all hearing requests, grant the petition for the creation of Northfield's Municipal Utility District Number 1 of Kaufman County, find that the petition satisfies all applicable statutory and regulatory requirements, and that the district is feasible, practical, and necessary, and would be a benefit to the land to be included in the district. Approve the district's request for road powers in accordance with Texas Water Code 54.234, and appoint the following 5 people to serve as temporary directors until permanent directors are elected and qualified: Daniel Benson, Birchfield; Hunter Diaz; Timothy Dury; Ryan Kolowich; and Sandra Stevens Wood-Mancy.
A second.
All those in favor say aye.
Aye.
Thank you. The motion passes. Let's move on to item 6, please.
Item number 6 is the consideration of the application by Megatel Homes 3 LLC and Trace Rios Property LLC for TIPD's permit number WQ00163900001. The parties have been notified that the commissioners will not take oral argument but may ask questions.
All right, item 6. Before us, we have an application for a new TIPD's permit that would allow the discharge of treated domestic wastewater at a daily average flow not to exceed 1.33 million gallons per day in its final phase. Again, for these type of applications, the Commission considers a 2-step analysis. First, we must determine whether a hearing requestor is an affected person. The TCEQ received 1 hearing request that was not withdrawn from Janice Newman. While Ms. Newman raised applicable concerns related to groundwater contamination, livestock, wildlife impacts, her property is not on or even near the discharge route and is more than 1.5 miles from the facility's proposed location. Given the location of her property relative to the proposed wastewater treatment plant and the discharge route, the concerns raised by Mrs. Newman do not establish a personal justiciable interest that is distinct from those of the general public. Therefore, I don't believe that she qualifies as an affected person, and I would deny her hearing request, issue the permit, and adopt the ED's response to comments. Colleagues?
I'm in agreement.
In agreement.
Do I have a motion?
I move that we deny the hearing request filed by Janice Newman, issue TIPD's permit number WQ00163900001 to Megatel Homes 3 LLC and Trace Rios Properties LLC as recommended by the Executive Director, and adopt the Executive Director's response to comments.
Do I have a second?
I second.
All those in favor say aye.
Aye.
Aye. Thank you. The motion passes. Thank y'all. Moving on to item 7.
Item number 7 is the consideration of the application by H.C. McKinney III LLC and McKinney Ridge LLC for new TIPD's permit number WQ 001-655-0001. The parties have been notified that the commissioners will not take oral argument but may ask questions.
Item 7, before us, we have an application for a new TIPD's permit that would authorize the discharge of treated domestic wastewater at a daily average flow not to exceed 0.75 million gallons per day in its final phase. Similar to items 3 and 6, the commission first determines whether a hearing requestor is entitled to a contested case hearing. This includes reviewing whether the requestor submitted timely comments on the application that were not withdrawn. If a hearing requestor did not submit timely comments during the comment period, that requestor cannot qualify as an affected person. The commission received one timely hearing request on this matter from Mr. Surinder Kakarini, who did not submit any comments during the comment period. Because he failed to meet the procedural requirement, I agree with the ED and OPIC that he cannot qualify as an affected person. As a result, I would deny Mr. Kakarini's hearing request, adopt the executive director's response to comments, and issue the permit. Colleagues, thoughts?
I agree.
I agree.
I move that we deny all hearing requests, issue the new TIPD's permit number WQ 001-655-0001 to H.C. McKinney III LLC and McKinney Ridge LLC as recommended by the executive director, and adopt the executive director's response to comment. Do I have a second?
A second.
All those in favor say aye.
Aye.
Thank you. The motion passes. We'll move on to the enforcement docket.
Okay, that takes us to our enforcement docket, items 8 through 37, with the note that items 18 and 31 have been remanded at the request of the ED earlier this week. The executive director's staff is here to present these items.
Good morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Megan Hamilton of the Enforcement Division, and with me today are Amy Sedemeyer, also of the Enforcement Division, and Gitanjali Yadav of the Litigation Division, representing the Executive Director. Pending before you are items 8 through 17, 19 through 30, and 32 through 37. The total assessed administrative penalties are $819,071, with $114,972 deferred, $509,958 applied towards supplemental environmental projects, and $194,141 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you. Do we have any questions for Megan? Mary, do we have anyone signed in on these items?
So on items 8, 12, 15, 20, and 22, there are individuals who are signed in. They don't wish to speak to the commission unless the commission has questions, in which case they're available.
Any questions? All right, OPIC?
Good morning, Chairwoman, Commissioners, General Counsel, and the Executive Director's Attorney and staff. For the record, I'm Pranjal Mehta for the Office of Public Interest Counsel. Our office has reviewed these items, and after review, we recommend approval of all items. We thank the Executive Director's staff for the hard work on this. Thank you.
Thank you very much. Thank you very much. As always, I'd like to thank everyone in OCE and OLS who played a part in getting these orders to us for approval today. I'm ready to move forward with them. I move that we adopt items 8 through 17, 19 through 30, and 32 through 37 as recommended today by our executive director. Is there a second?
I second. I also want to thank the staff as well.
Oh, I'm sorry.
That's okay.
I robbed them of the thank yous. All those in favor say aye.
Aye.
Aye. Thank you. The motion passes. A little too rapid these days.
Item 38 is the consideration of the monthly enforcement report, and the executive director's staff is also here to present this matter.
Good morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. My name is Amy Sedemeyer of the Enforcement Division, and with me are Christy Mills-Jurak and Melissa Cordell of the Office of Compliance and Enforcement, and Gitanjali Yadav of the Litigation Division. We are here to present the monthly enforcement report for fiscal year 2026 through February. There were 769 effective administrative orders issued, and of those, 111 contained supplemental environmental projects. These orders assessed a total of $13,506,753, with a payable amount of $7,833,077. $3,786,028 are to be paid towards supplemental environmental projects. 8,127 notices of violation have been issued either through our field offices or review of self-reported data in our central office, and 653 enforcement action referrals have been received. There are 2,776 pending administrative orders with 1,255 cases that are on the backlog. 161 cases are pending at the Attorney General's office for representation in district court, and 5 judgments have been issued. 1,731 cases are being tracked for compliance. We're available to answer any questions you may have.
Thank you, Amy. Mary, has anyone signed in on this item?
Yes, on this item, we have Catherine Guerra signed in.
Ms. Guerra?
Before we do that, I do have a question for the staff. Can we do that first before we? Sure. Okay. If I'm seeing this correctly, I see the backlog has been reduced by 130 cases this month. Can you talk about what your team has been doing to reduce the backlog?
Thank you for that question and for the recognition of the reduction in our backlog. The Office of Compliance and Enforcement and Office of Legal Services have been working together to implement measures to address the backlog, as you know, for a few years now. This includes ensuring all of our positions are timely filled, training staff to handle both the complexity and the volume of workload, and streamlining case development processes. Recently, we've also created a team specifically to focus on reducing the backlog. The reported backlog number is a dynamic measure of our workload at a moment in time. This number reflects a point-in-time snapshot of a process that's constantly in motion, with cases moving on or off the backlog as they're addressed throughout the process. Our ultimate goal is always to keep pace with incoming cases, reduce aging items, and prevent new backlog from forming. OCE and OLS have continued to work diligently to not only reduce the overall backlog, but also manage newer cases efficiently in order to prevent new backlog. Within OCE, and specifically the Enforcement Division, we've continued to work diligently on training and retaining staff, streamlining processes, and ensuring that we are managing cases efficiently. Additionally, as mentioned a moment ago, we have a team of employees managed at the office level who are focused on a group of backlog cases with the ultimate goal of appropriately managing all of these cases by the end of the fiscal year. Within the division, staff has remained focused on not only addressing any older cases, but also on keeping current work moving forward. That balance of reducing backlog while not creating new requires consistency and strong day-to-day execution from all staff. Additionally, with OLS, the Litigation Division has recently received 5 new attorney positions to help with backlog and overall case workload. What you guys see in the report is the result of a collective effort across OCE and OLS. It's been a fundamental shift in how we're approaching and how we're operating our workload, and we're all working together towards a shared goal. We do have more work to do, but I do believe the momentum that we've gained and built is real, and it will result in lasting changes.
Absolutely. Commissioner Miller.
Thank you for that. And when I met with you guys, I just want to point out 2 things that you just said. One, you created a whole new team to address this, and that's just great and shows the dedication. And 2, you put this team at the office level. And we know that if you put something at the office level, that means it's a high priority and it's going to get daily interaction at the office level, and that's very important. So I just want to thank you for recognizing that, for thinking outside of the box, doing things a little bit differently to address this issue. So thank you. You guys are great.
Yeah, I appreciate the efforts that your team's making to reduce that despite the significant turnover that y'all have faced in your division. And thank you to your staff your work on these items and all the work you do on the day-to-day, which I think goes way beyond what we see in these meetings. Really appreciate it.
Well, I just echo what my two fellow commissioners have said. A reduction of 130 enforcement orders is no small feat. And I love the fact that we have a strike force now attacking our backlog. I really appreciate, Christy and Amy, your innovative ways to address this backlog. I know you want to clear it as much as we do and as much as the citizens of Texas do, and we're going to do it. And y'all are doing the right thing. So we really appreciate it. All right, there's no action required.
We have the commenters still and OPIC. We have Catherine Guerra signed in on this item.
Good morning, Commissioners. Can you hear me? Good morning. Can you hear me, Commissioners?
Yes, we can.
I'm Catherine Guerra with Public Citizens Texas Office. I serve as Director of the TCEQ Watchdog Campaign and Agency Accountability and Community Capacity Building Initiative. We've reviewed 10 years of TCEQ's monthly enforcement reports tracking net increases and decreases in the year-to-date summary, and during that time, the agency has never resolved more than 70 backlogged enforcement cases in 1 month. And I noted, however, like Commissioner Gonzalez, on this monthly enforcement report that the agency closed 130 of its nearly backlogged 1,400 nearly 1,400 backlogged enforcement cases between January and February. And while, as Ms. Sedemeyer said, the agency still has a way to go, this is an accomplishment that is certainly worth acknowledging. I'm not clear, however, how the cases were resolved. I want to confirm that none of those backlogged cases were disposed through the expedited compliance order program that was implemented in mid-February, since the backlogged cases wouldn't meet the 60-day requirement for resolution under that new program. Also, I submitted a request under the Texas Public Information Act for the backlog case data sets from January and February, and while we're still taking a look at that data, I just did want to point out that there are approximately 40 new enforcement cases from 2022 to 2024 added to the February data set of backlogged cases that were not present in the January data set. So we'll have some questions for staff about that data. Last week, it also appeared that TCEQ removed 10 years of monthly enforcement reports like this one from its website. More than 100 reports on the agency's performance were deleted with a note that you had to search the Commissioner's integrated database for those reports going forward. I emailed OCE that day and just to ask why they were removed and when the information would be restored, since agency performance data is necessary for transparency and accountability, and it should always remain accessible to the public, and we appreciate that it was restored yesterday. Another transparency issue is that we noticed that it had been a while since TCEQ has had a public comment opportunity. The last was on April 1st, which was also the last opportunity the public had to speak about the enforcement backlog. There's not a public comment opportunity today. There's not one posted on the May 13th draft agenda. The next opportunity after that is nearly 5 weeks away on June 3rd. So we believe more, not fewer, interactions with the TCEQ and public are in the best interest of both parties. In this case, there's a 2-month wait between public comment opportunities. Perhaps that's an oversight, but when public comment is restored to the agenda, we ask that you not underestimate what it takes for the public to participate in these meetings and allow them the opportunity they deserve to be heard. For the opportunity prior to this one, some of the folks boarded a bus at 6 a.m. just for that 3-minute opportunity to speak to you. Public comment opportunities aren't just for Texans to speak about how the agency can and should better serve the public and address environmental concerns. Public comments are opportunities for you to listen to Texans' sincere concerns. So we just ask that you do that by restoring the public comment opportunity and giving folks their full opportunity to be heard. Thank you.
OPIC? Morning.
Good morning, Chairwoman, Commissioners, General Counsel. For the record, I'm David Timberger, Interim Public Interest Counsel. OPIC has reviewed the report and appreciates staff's efforts to move these cases forward and recognizes the substantial strides that have been made. Thank you.
Thank you very much.
I have one more comment, if that's okay.
Absolutely.
Just want to highlight another thing I noticed, that the Enforcement Division conducted over 101,000 total investigations with more than 63,000 on site and issued 1,170 orders in fiscal year 2025. I think that our enforcement process encourages entities to come into compliance as soon as possible, and our staff guides this process, which protects human health and the environment. Our ultimate goal is compliance, and I think the division's doing a great job of working with the regulated entities to ensure compliance. So again, thank you.
Any comments from you? No additional comment, though. We are a compliance-first agency. No action is required on this report. Mary, please call the next item.
Item 39 is the consideration of the publication of and hearing on proposed amendments to 30 Texas Administrative Code, Chapter 309, Domestic Wastewater Effluent Limitations and Plant Siting, and Chapter 210, Use of Reclaimed Water to implement Senate Bill 1145, both from the 89th Legislature. The Executive Director's staff is here to present this item.
Good morning.
Good morning, Madam Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Shannon Gibson with the Water Quality Division. With me today is, Brian Rakowitz with the Environmental Law Division and Greg Easley also with the Water Quality Division. The proposed rulemaking before you today would partially implement changes to the Texas Water Code made by Senate Bill 1145 from the 89th regular legislative session. Senate Bill 1145 amended Section 26.131 of the Water Code to transfer permitting authority for land application of produced water that is treated for beneficial use from the Railroad Commission of Texas to TCEQ. This rulemaking proposes to amend Title 30 of the Texas Administrative Code, Chapter 210, regarding use of reclaimed water. The proposed amendments would add 2 sources to the exceptions to the wastes ineligible for coverage under Section 210.54. Specifically, the proposed rule would add processed wastewaters regulated under Title 40 of the Code of Federal Regulations, Parts 435 and Part 437, regarding oil and gas extraction point source category and centralized waste treatment point source category, respectively. In addition, this rulemaking proposes to amend 30 Texas Administrative Code, Chapter 309. The proposed amendments would clarify the chapter's applicability to the land application of industrial wastewater, which includes produced water that has been treated for beneficial use. The proposed rules clarify that the minimum requirements established under Chapter 309 for the land application of treated wastewater apply to the land application of produced water that has been treated for beneficial use. The proposed rule would also retitle the chapter as Wastewater Effluent Limitations and Plant Siting. TCEQ's jurisdiction over facilities seeking authorization to land apply or otherwise reuse produced water that is treated for beneficial use under Chapters 309 or 210 is described under 30 Texas Administrative Code, Section 7.117, regarding the Memorandum of Understanding between the Railroad Commission of Texas and TCEQ. Rulemaking to implement Senate Bill 1145 under the MOU between the Railroad Commission and TCEQ is currently in progress. A public hearing on this proposal is scheduled for June 15, 2026 in Austin, Texas. Staff respectfully recommends approval to propose the publication of and hearing on Chapter 309, Sections 309.1, 309.2, 309.10, 309.11.13, and .20, and Chapter 210, Section 210.54. In addition, staff request permission to make non-substantive revisions to comply with Texas Register requirements. Thank you, and we are available for any questions.
Thank you very much. Has anyone signed in on this item?
No one is asked to address the commission on this item.
All right, OPIC, please.
Good morning, Chairwoman, Commissioners, General Counsel, and Executive Directors, attorneys, and staff. For the record, I'm Michael McCarthy on behalf of the Office of Public Interest Counsel. OPIC has reviewed this proposed rulemaking and respectfully recommends publication.
This rulemaking is required to implement Senate Bill 1145 from the 89th regular legislative session, which amended Texas Water Code Chapter 26, Subchapter D, in order to transfer permitting authority for the land application of produced water treated for beneficial use from the Railroad Commission of Texas to TCEQ for applications filed on or after September 1st, 2025. The proposed rulemaking would amend 30 Texas Administrative Code, Chapter 309, to clarify applicability to the land application of industrial wastewater, including produced water, and establish minimum requirements for land application of produced water under TWC 26.131. Rename the chapter Wastewater Effluent Limitations and Plant Siting, and establish minimum requirements for land application of produced water. The proposed rulemaking would also amend Chapter 210, Subchapter E, to add produced water regulated under 40 Code of Federal Regulations, Parts 435 and 437, to the list of processed wastewater exceptions that may be authorized for reuse under the subchapter. This rulemaking is statutorily required and necessary for TCEQ to assume the new permitting authority under SB 1145. Stakeholder involvement will include regular updates and outreach through the Water Quality Advisory Work Group, as well as a public hearing during comment period. As with other land application authorizations, members of the public may have concerns about potential impacts to air quality, odors, or well water contamination from land application sites. The rulemaking process will provide an important opportunity to provide public comments related to those concerns and other aspects of the proposed rulemaking. We look forward to monitoring this public participation and bringing any identified public interest issues to the attention and consideration of the Commission. Thank you, and I'm available for any questions.
Thank you. This rulemaking proposal implements Senate Bill 1145, which transferred the permitting authority for land application of produced water that is treated for beneficial use from the Railroad Commission to TCEQ. In my review, the proposed rules appropriately implement SB 1145, establishing the requirements and a permitting mechanism applicable to authorizations for land application of produced water. The proposed rules also make clarifying changes. I'd like to thank staff on their work on this proposal. I'm eager to hear what the public has to say, and I'm ready to move forward. Katarina?
I just want to say that I appreciate the legislature placing its trust in us to carry out this responsibility, and I'm encouraged to see this rulemaking proposal move forward. It's critical that we get this right, and I want to recognize and thank our staff for the significant work already invested in both this rulemaking and the related permitting efforts. Our team brings substantial experience in TLAP permitting, along with proven processes that will provide a strong foundation as we take on this new waste stream. I appreciate staff's commitment to ensuring that our permits are grounded in sound science, incorporate innovative treatment technologies, and protect public health and the environment. I also look forward to robust public comment, which will be an important part of this rulemaking project.
Well said. Commissioner Miller.
I agree with both of your comments.
Thank you. I move that we approve the publication of and hearing on the proposed amendments to 30 Texas Administrative Code Chapters 210 and 309 as recommended by the Executive Director.
Second.
Is there 1 second?
A second.
Okay. All those in favor say aye. Aye. Thank you. Motion passes. Thank you.
Okay, the next items are for closed session. The commission will be meeting in closed session in room 4222, Building F, at 11 a.m. as permitted by the Open Meetings Act, including Texas Government Code Sections 551071 and 551074, to take up and consider matters pursuant to items 40 through 43 as posted and noticed.
Thank you. This meeting stands in recess. The time is 10:44 a.m. Thank you very much.
The commission met in room 4222 of Building F for closed session from 11:05 until 11:48 a.m. on items numbered 40 through 43 as posted in notice pursuant to Texas Government Code Section 551.074. No action was taken. This agenda stands adjourned. The time is 12:06.